Thank you so much for joining. Oh, yes. This meeting will be recorded, and Christine will explain a little bit more about that when I turn it over to her. So today we'll just start off with a quick introduction to MWBC. Give me one moment while I share my screen. Can everybody see my screen? Yes. Okay, perfect. Thank you. So we are the Maryland Women's Business Center. Thank you so much for joining us today. We are a nonprofit that aims to help women and minorities start, sustain, and grow their businesses. We are headquartered in Rockland, Maryland, but we serve Montgomery County, Frederick County, Prince George's County, as well as Howard County. We offer business counseling for businesses in all stages, as well as training and events both in person and virtually, as well as access to business resources. If you'd like to learn more about our counseling sessions or are interested to sign up or would like to learn more about our training and events, please feel free to scan the QR code on the screen. And with that being said, I will turn it over to Nick, and then we'll have Christine present. Thank you.
Great. Well, thank you, Senia. Good morning, everyone. Pardon the fact I'm having trouble with video here. I'm having tremendous IT issues this morning. But anyway, my name is Nick Rajpara. I'm with the SBA field office in Washington, D.C. So our field office covers all small business concerns. Well, let me just take a step back. The SBA, the Small Business Administration, is a dedicated agency for small business concerns throughout the United States and its territories. Our field office covers business concerns in the greater Washington metro area. I'm an economic development specialist. While it is, I will put my email in the chat, but I wanted to just, say a couple of quick words about this. First of all, it's an absolute pleasure to be in partners, put this together, co-host this in partnership with the Maryland's Women's Business Center. That nice slide that Yesenia had up on the screen, it had a little logo of the SBA. It's empowered by the SBA because the Women's Business Center in Maryland and all women's business centers throughout the country are funded by the SBA in part, by the SBA. And of course, the Small Business Administration just does not only fund women's business centers, they also fund what we call their SBA resource partners, such as small business development centers, SCORE chapters, and also Veterans Business Outreach Centers. All these resource partners, except for the Veterans Business Outreach Center, are in every state in the U.S. territory. If you need help connecting with any of these resource partners, reach out to me. Like I said, I want to put my email in the chat. Another thing that our office loves to do is work with extended partners, such as the DC Bar's Pro Bono Center, who have been just excellent, awesome partners of ours, throughout the years. And I could attest to this because I was first with a resource partner, the DC Small Business Development Center, and I used to work with the DC Bar Pro Bono Center with Christine's predecessor, and we just had a wonderful relationship. And with Daryl, and he handed it off to Christine, who has just done an awesome job. Not only in bringing together these very topical areas for small businesses, but also with the counseling that they do for businesses as well. I do not know how they do it, but they serve a vast array of small businesses, and on a pro bono basis. So I will let Christine talk about that. Her and her team just works magic all the time. So I'm just really, really excited. And of course, this topic that we're covering today is new. It went into effect this year. And, I get a lot of questions from the field about it. So I'm so glad that we're addressing this and we're having this today. And Christine's presenting this, having this presentation in a very topical area. Anyway, without further ado, Christine, I'll hand the floor over to you.
Thank you, Nick. So I am Christine. I am a managing attorney at the DC Bar Pro Bono Center. As Nick was mentioning, we do a lot of things to help small businesses in the DC area. We provide one-on-one brief legal advice where small business owners can talk to a lawyer about any legal issues or questions they have. We also do trainings such as these, and we have an online resource library, lawhelp.org/DC/NPSB, where there are resources on a wide range of topics for small businesses and nonprofits, from starting a business, intellectual property, employment law, commercial real estate, and so many other topics that can help your small business navigate the legal world, which is quite intimidating. Okay, and so before we jump in, a couple of just rules of the road. Please hold off on questions until the end to make sure that we can get through things, and in case you have questions that we are already going to cover. As Yesenia mentioned, this presentation will be recorded. You also will get a copy of the slides. Those will be emailed to you. Also, on the topic of questions, please keep questions to general legal questions. This is an informational webinar today. I will not be giving one-on-one legal advice. And so if you have questions that are specific to your business's circumstances and how the topic applies to them, that would be best addressed through one-on-one legal advice, whether through the Pro Bono Center or elsewhere. Okay. So today we are chatting about demystifying the Corporate Transparency Act. New legislation. What is the Corporate Transparency Act? It is something that we have heard of. That's why we're on here today. But it's new, maybe unfamiliar. Some background on the Corporate Transparency Act. This is a federal law that was recently enacted that has reporting requirements for many businesses in the US or operating in the US, and that includes LLCs and corporations. The law and the requirements under it were designed to combat some financial crimes, money laundering, tax fraud, corrupt activities, and other types of financial crimes that could be hidden or mislead, make it hard to figure out the identities of the people doing the crimes by using corporate structures to shield them, such as an LLC or a corporation or multiple LLCs or corporations. This legislation was specifically designed to target small businesses, which is different than a lot of federal laws that relate to businesses. Most are big businesses. Here we're thinking small, micro. And it's a little bit different. Because it was targeting small businesses, the agency that is in charge of enforcing, FinCEN, the Financial Crimes Enforcement Network, which is part of the US Treasury, has a process where they tried to make sure that small businesses are able to easily comply with the law. It's not expensive or difficult. However, there were some things that they could not budge on because the law said we have to collect certain information on small businesses that need to report. The process is relatively new. It is not perfect, but I think that it is doable. So there are reporting requirements under the CTA. Who do they apply to? Does your business need to worry about it? Does a business you know need to worry about it? First, we call businesses that need to report under the CTA reporting companies. A reporting company under the law is a domestic entity created by or a foreign entity registered to do business in any state or the District of Columbia by filing a document with the Secretary of State or a similar office. So in DC, that's going to be the Department of Licensing and Consumer Protection, formerly the Department of Consumer and Regulatory Affairs. In Virginia, it's the Virginia Corporation Commission. In Maryland, when you file to create a business entity, that will be with Maryland Business Express. That's what they mean by the Secretary of State or similar office. We just so happen to live in a region where none of them are called the Secretary of State. Reporting companies looking at filing a document to create the entity. Here, that will include LLCs and corporations. To form an LLC, articles of organization are filed to create the separate legal person that is the business. The same is for corporations when you file the articles of incorporation. Limited partnerships and limited liability partnerships are a little bit less clear. We aren't sure entirely if those are reporting companies. Does the business exist? Does the entity exist without filing with the Secretary of State? Here, we do not need to worry about sole proprietorships and general partnerships being reporting companies. If you are a sole proprietor or a general partnership, your business exists without filing a document to create it with the government. I want to be clear here. If you have a sole proprietorship or a partnership and you have filed with the government for a trade name, a DBA, a fictitious name, anything to call your business that is not the legal name as a sole proprietor, your name, that does not require you to become a reporting company at that point. Your business exists whether or not you have that trade name. So keep up with that trade name, make sure that your local jurisdiction doesn't have any requirements related to it, but having a trade name is not enough if you're a sole proprietor or a general partnership to be a reporting company. There are some exemptions. This is nice because maybe you will not have to report under the Corporate Transparency Act. However, I will say that most of these exemptions aren't going to apply to the average small business because the exemptions are for, industries that small businesses are typically not in, or because the businesses already overlap with federal reporting or state oversight, which many small businesses don't. So we're thinking of businesses that already are going to be regulated, publicly traded companies, security issuers, insurance companies, state licensed insurance producers, so that may actually be some small businesses, tax exempt entities, entities that here tax exempt means have a 501c exemption from the IRS, and possibly some other entities that are defined in the law that have existing oversight and reporting requirements. So for most small businesses, if you are an insurance producer or a tax exempt entity, you could be exempt from the CTA reporting requirements. The other potential exemption that could apply to small businesses, though not micro businesses, are going to be large operating companies, which are not necessarily large, and it seems silly since this is a small business targeted law, but we think of large operating company as meeting all three of the following requirements. Just one, just two is not enough. To be exempt as a large operating company, the entity must employ more than 20 employees on a full-time basis in the United States. They must also have an operating presence in the US at a physical office. Finally, the business must generate more than $5 million in annual gross receipts or sales. All three of these requirements must be met to be exempt from the reporting requirements. If a business has 25 full-time employees in the US and has a physical operating presence in the US at an office, but has less than $5 million in annual gross receipts or sales, they are not exempt. Another final exemption that I'm going to cover that is unlikely to apply to many of you today are that a fully owned or controlled subsidiary of An entity that is exempt is also exempt. So if there is an exempt corporation that fully owns, fully controls, is a 100% owner of 3 LLCs, even if those 3 LLCs themselves do not meet an exemption, so long as they are fully owned or controlled by that corporation that is a large operating company exemption, they do not need to report. They get that exemption. But what information goes into this report once you know, okay, our business has to do it? First, these reports will be filed with FinCEN, and there's some information that has to go into it. So first, there will be information on the beneficial owners of the business. And we'll get into this a little bit more, but beneficial owners are going to be any individual who directly or indirectly exercises substantial control, we'll dive into that, of a reporting company, or who owns or controls at least 25% of the ownership interest in a reporting company. Also, information that needs to be reported on company applicants. These are going to be individuals who file or help prepare the document that creates the reporting company. This is if an attorney or a third party prepares the articles of organization or incorporation and files them with the state. There is, for an initial period for existing businesses, a time where they do not need to report company applicants. So if you have an existing reporting entity, right now you do not need to worry about filing company applicant information. But we do need to worry and think and identify our beneficial owners. The 25% ownership is generally going to be a bit easier to identify. Your business should have documentation of who the owners are and how much they own. If you have an LLC, this information will be on an attachment or an exhibit to your operating agreement that will be kept up to date. As a corporation, you will have issued stock certificates and you will have a shareholder list or roll. That will tell you who owns how much, and you can calculate, okay, 25%, yes or no. Where it gets a little trickier is figuring out if an individual exercises substantial control over the entity. Some ways that we can figure out if an individual exercises substantial control are they serve as a senior officer of the reporting company. They have authority to appoint or remove or change senior officers, or a majority of the board of directors, or something that functions as of the board of directors but may have a different name. Also, they exercise substantial control when they direct, determine, or have substantial influence over important decisions. Again, more words that we have to figure out what they mean. Important decisions that show that the individual is exercising substantial control include a few of the following: selling, leasing, mortgaging, or transferring assets that are key and principal to the reporting company. Major expenditures or investments, issuing equity, incurring significant debt, approving the budget for operating of the business. And here, this is going to be incurring significant debt, not charging $500 for a regular business expense onto the business credit card. Important decisions, big picture. And this last example is really big picture. Choosing, changing, ending, altering the lines of business of the reporting company, the ventures they go into, their geographic focus, what they're doing, where they're doing it, how they're doing it, shifting it. Generally, somebody needs to make, that's a very big decision for a reporting entity. That isn't something that somebody who exercises no control has the authority or ability to do. Entities, reporting companies may not have one single owner that's a beneficial owner that owns more than 25% or 25%. You may have a small business with 10 owners that each own 10%. So there's nobody that satisfies the ownership interest prong. However, a reporting company should always have at least one beneficial owner that meets that substantial control component. There has to be at least one person behind the business making the decisions, calling the shots, that has that decision-making authority and that control. So there will be at least one beneficial owner that needs to be reported. Some of who may be considered or thought of as a beneficial owner under the definition are exempt, or there are special rules for. First are minor children. An individual that's a nominee, custodian, or agent for another. Individuals who have a future potential interest through inheritance in the business. If there is somebody who knows that they are going to inherit their parents' 75% ownership in the family business, when the parent passes, that is a future interest, and they are not a beneficial owner at this point. Creditors are generally also not going to be beneficial owners. Going back to this one in the middle, this is big. An employee of a reporting company who is only an employee and but they do have substantial control over the entity, but that's only from them being an employee, not as a senior officer, is not a beneficial owner. So if we go back a couple of slides, we'll look at sale, lease, mortgage, or other transfer of principal assets of a reporting company. That a business may be in real estate, and essential to what they do, all of their assets are going to possibly be principal assets. An employee who is not a senior officer that leases their principal assets, the flagship building, but is only an employee, and that is why they demonstrate and exercise that substantial control, is not a beneficial owner. They are doing their job as an employee if they are not a senior officer or an owner of the business. Looking at those situations, it will be circumstantial. It won't apply to every employee because they may be a senior officer. So you will want to do an analysis of senior officers and their roles. Okay, so we figured out, hopefully, who are the beneficial owners. Now, there's certain information on the company and those beneficial owners that needs to go into the report. For the reporting company itself, for the entity, their full legal name, any trade name, again, also that can be known as DBA or fictitious name, the current street address, the jurisdiction where the reporting company was formed or is registered, and the IRS taxpayer identification number or employer identification number. Also, for the beneficial owners themselves and company applicants, if that needs to be submitted, have their own list of information, the full legal name, their date of birth, a current residential address, and both the information from and an image of a non-expired eligible US identification document. If that US identification document is not available, a foreign passport can substitute. Both the information on it, the issue date, expiration date, what government issued it, the identifying number, and also that picture, that image that goes along with it. So all of this information needs to be reported. When does it get reported? For newly formed entities, if it's a reporting company that was created on or after January 1st of 2024, up until January 1st of 2025, these new entities have 90 days from the earlier of the dates to file their initial report. So they receive notice that the entity is effective with the government or the entity, the jurisdiction where they filed to create it, or when the Secretary of State provides public notice that the company was created or registered. If on January 1st of 2024, an entity files their articles of organization with the Secretary of State, and 3 days later, they get notice that the entity is effective to do business on January 3rd of 2024. They have 90 days from that date to file their initial report. Beginning in January of 2025, new reporting companies have 30 days to file their initial report. The 90 days is a special exception that applies right now just for this first year while everybody is adjusting to the new system. For existing entities, which many of you may be, if your reporting company was created before January 1st of 2024, your initial report must be filed by January 1st, 2025. That is a Wednesday. This gives plenty of time to report. We're in March right now. You have some time to figure it out and plan ahead. These initial reports that are filed by existing or new entities need to be updated. It is not a one-time filing that stays that way forever necessarily. Updates must be made within 30 days of changes to previously reported information, or the reporting company learns that previously reported information is not accurate. If information on a beneficial owner changes, if the beneficial ownership itself changes, 30 days to update that information. Also, there's no requirement to report changes in information about the company applicant. Who that company applicant is will not change. Whoever filed the articles of organization or incorporation to create the entity only does so once. And if their address changes, that is okay. That does not need to be updated. But other information, you have 30 days to update. Make sure that if things change, you keep up to date with updating. Okay, so how do we actually report all of this stuff that a reporting company needs to do? Reports will be filed online at FinCEN's website. The link is right there. You can also Google it. there are two ways on their website that the beneficial ownership report can be filed. The information can be entered electronically into their site. Or you can go onto their website, download a PDF, complete the PDF, and then upload it. Also, through that website, when it is filed, the pictures of identification documents for beneficial owners will need to be uploaded. The reports that are filed through this website are sensitive information, and they will be kept confidential. This is not public information. Certain government authorities and some financial institutions will have limited access. Again, this is not public information. You are not going to an unsecure website that is, you're going to type in everything and 2 minutes later, any person can look up your business name and it will have beneficial ownership information report. A couple of practicalities: file on a computer, not a tablet or a cell phone. If that means you need to go to the library in order to file, please do so. Or if you need to set aside time and make plans. These types of systems are designed for computers. They are not optimized for cell phones or oftentimes tablets, which are sort of this in-between world. It's not a mobile site, it's not a desktop site. Also, if you decide to download the PDF to complete and then upload, you may need to update or download a new PDF reader. When I downloaded a copy of it, I didn't have the proper version of Adobe. So I needed to open it with a different Adobe Acrobat in order to even see the document, not to fill it in, just to see the fillable PDF. So be aware of that it may take a little bit of technological work to get through there. For this website and the filing, a business can file for themselves. You do not need to have an attorney or an accountant file for you. And in fact, many will not file for you. They may help collect or gather information that is going to go into it, help you determine who beneficial owners are. But you can file for your own business and are encouraged to do so. Filing is also free. Again, going back to this legislation targeting small businesses and wanting to make it accessible and low cost. What happens if you have a reporting company and you don't comply? Are you liable? There are some serious penalties. So the reporting company itself, beneficial owners, and company applicants all could be liable for only willingly providing false beneficial ownership information. It must be willful and it must be false information. If the information is incorrect and it was not willful, it was accidental, there's that 30 days from learning the information is wrong to update it. Also, any person that causes a reporting company to not report or is a senior officer at the time when a reporting company fails to report can be personally liable for those violations. That individual is stuck paying the money, them personally. It's a little bit, it's a potential hefty penalty. Also, when we're thinking about, okay, well, what actually happens? Is there money? What does that look like? There is a civil fine up to $10,000 at a rate of $500 a day that a violation is outstanding. If a reporting company is required to file and they don't, $500 a day until they do, or until they reach $10,000. $500 a day is a lot for anybody, and especially for a small business, and $10,000 is really a lot. Not just potential money, but there are criminal penalties. And for failure to report, it's a maximum of 2 years imprisonment. Going to jail or prison for not following the reporting obligations. Nobody should have to do that. Don't let your business be in that situation. So what now? What are the next steps? How does your reporting company prepare? What you can do right now to prepare is exactly what you're doing right now. Gather information on your reporting obligations and requirements and ask questions. Ask questions to lawyers. Ask questions of other business owners that have already filed. Ask questions of technical assistance providers. Also, a really important step is figuring out and determining who beneficial owners are right now and when you file, but also establishing procedures for figuring out and tracking when the beneficial owners change. Are you going to set regular interval check-ins? Will it be tied to events or changes in structure? Anytime you bring on a new owner or there are changes on a board. Figure out what is going to work for your business so that you can keep up to date with the beneficial owners. Who are those people making the big decisions or owning more than and controlling more than 25%, so that you update that. Also, collect all of the necessary information and documents before you file. You have time now to get everything that is required on both the reporting company and the beneficial owners. Start doing that. Finally, file your initial report or set a reminder on your calendar to file. If you are an existing entity, right now you have until January 1st, 2025 to file. I do not recommend that you wait until the last 12 hours. Set a reminder ahead of time and do it a little bit in advance. And put multiple reminders in case when the first one pops up, you are busy with doing something else for the business. That is okay, but it needs to happen. So set a reminder, set another reminder. Okay. So some of the basics. But what about the lawsuit? I heard that the Corporate Transparency Act was unconstitutional. If any of you have heard about this, there is a case called the National Small Business United versus Yellen, and that is Janet Yellen, Secretary of the Treasury, and other government parties. On March 1st of this year, the U.S. District Court for the Northern District of Alabama did find the Corporate Transparency Act to be unconstitutional. The court found that the law was an impermissible exercise of Congress's power under foreign affairs and national security to regulate interstate commerce and taxation. They said, hey, this law doesn't necessarily all of these situations apply to national security. It's regulating internal affairs, things that relate to states. That is one court. Despite the fact that this one court found the Corporate Transparency Act unconstitutional, the law is only not enforceable against the plaintiffs in this one case. That is members of the National Small Business Association as of the decision on March 1st, 2024. Right now, everybody else needs to comply. and you can't join the National Small Business Association right now to try and get out of compliance. The Treasury has appealed this court's decision. What is going to happen on appeal? If there will be further appeals, if it will go to the Supreme Court, and how long any of that may take is entirely unknown. We have to wait and see. So now what? We just wait and see. Well, there are more cases using the same argument that are being filed in other courts. We can't predict the timelines, how long those will take to be resolved, or what the outcomes will be. There is a chance, a reasonable chance, that other courts may not agree with the Northern District of Alabama. So do not rely on, well, one court found this, so that means the other courts will agree. Not necessarily. All reporting parties that are not a part of the case should continue reporting as required under the law until further notice. FinCEN has already said and put up a notice on their website that they will continue to enforce the law against all other reporting companies. This is not an out right now. But because this is very evolving, keep an eye and an ear out on any changes or future guidance. Staying in touch with the Maryland Women's Business Center, with other technical assistance providers, small business or professional associations that you're a part of, on Facebook, on LinkedIn, putting an alert on your Google News, anything like that, just to stay up to date with what's happening so that you know, okay, my business is doing the right thing. We're keeping up with what has to be done. There are also some other local and state beneficial ownership disclosure requirements that I want to compare to and raise for you. So, DC, the District of Columbia, for all entities that are required to register with the Department of Licensing and Consumer Protection, has had a beneficial ownership disclosure requirement since 2022. This is for both domestic entities that are created under the laws of DC and foreign entities, a business that was created elsewhere and it is authorized to do business in the district. So DC has that already. New York has a new beneficial ownership reporting requirement for limited liability companies that will go into effect. It was just changed to 2026. Right now, those are two jurisdictions that have beneficial ownership reporting requirements, or at least some entities. California and some other states are currently considering legislation about beneficial ownership reporting so that they know who are behind these businesses. It is unlikely that a business's obligations as a reporting company under the Corporate Transparency Act supersede the state or local law. That means a business may need to comply with more than one. A DC LLC may need to file their local DC beneficial ownership information and file with FinCEN. Right now, assume that that is how it works. Also, just because an entity is not required or is exempt under the Corporate Transparency Act from reporting beneficial ownership information does not mean necessarily that they are exempt at the state or local level. Different legislation can have different exemptions. My understanding is that the New York LLC law will track the exemptions in the Corporate Transparency Act. The District of Columbia does not have exemptions. New states may or may not. Also, the definition of beneficial ownership can be different at the state and local level than it is at the federal level. In DC, again, the ownership threshold for a beneficial owner is lower than 25%, which is what the Corporate Transparency Act sets. And so as more states potentially implement these laws, or if you're operating in somewhere that already has it, keep in mind that the requirements and the definitions and how it applies to your business may not necessarily line up. And please, again, especially in your home local jurisdiction, keep up to date if something is being implemented. So many of you may be in Maryland, just keep an ear out as legislative sessions happen if there is any beneficial ownership reporting requirements that are proposed, so that you know, okay, maybe this needs to be on my radar on top of the Corporate Transparency Act. Okay, and with that, we do have a bit of time. Do we have any questions?
It looks like Katharina asked one question in the beginning. She said, will it include a business that is an LLC but has a sole member? I don't remember exactly what slide you were on when that question came up.
Great. So here we are looking at the business entity itself, the LLC. So if an LLC is a single member LLC or a multi-member LLC, it is a reporting entity. Here we are looking at the business entity itself, the legal structure, and not how the entity is taxed. So a single member LLC may be taxed as a sole proprietorship, but if their legal structure is an LLC as a separate legal person, they still need to report under the Corporate Transparency Act.
Great, thank you. And if anybody has any more questions, please feel free to unmute yourself or type them in the chat. We do have about 10 minutes left for today. So please take advantage of the time if you have any questions.
I have a question about nonprofits. I just want to confirm, so if they're a nonprofit, but not a 501c3, then they still have to report. Is that correct?
That is correct.
And then each time they change the board, they would need to update that because those are the principal officers.
Generally speaking, yes, that is correct.
Okay.
You know, it would need to go through again that analysis of, do those officers, do they actually have decision-making authority? Are they sort of just a sham board? But yes. And I will highlight that for some organizations that are viewed as nonprofits, that are incorporated as a local nonprofit, but do not have 501c3 tax exempt status. So certain homeowners associations, condominium associations, housing cooperatives. Right now, under the law, they are required to report. There is a push for legislation that would exempt some of them. Don't know if that will happen. You know, that would require some more effort on Congress and within a certain timeline. So plan, even if you are part of one of those, to need to report and, you know, make all the plans, take all the steps, and then we will see if before January 1st, anything has changed.
Thank you. And then we have another question from Cheryl. Clarify again regarding nonprofits. Safe to say, if not able to accept tax exempt donations, then must report?
Not exactly. We want to look at the type of tax exemption the organization has. So if they have a federal exemption from the IRS that falls under section 501C, then they are an exempt reporting company.
Okay, thank you. Does anybody have any more questions? Cheryl says thank you.
Absolutely. And again, this is an evolving topic. So you may think of questions, the news may change, stuff may happen. Feel free to come back to the Pro Bono Center, visit our website for updates on what is going on. And another question I just saw pop up, what happens if an entity that is required files and then the law is repealed or found unconstitutional for everybody? The information that was reported will still say secure in FinCEN's reporting system. It won't become public information just because parties are no longer required to report.
Great, thank you so much. And in your slides, I believe, is your contact information on there? Should they contact you, or is there?
Yes, so in the slides, there is the contact information for the Pro Bono Center's nonprofit and small business legal assistance team. You can reach out to us and we will direct you to the appropriate resource that we have, depending on what type of an organization you are.
Okay, perfect. Thank you. And like we said, everybody, these slides will be shared. So if you have any more questions, please feel free to follow the contact information on the slides. And I believe there are no more questions. So Christine and Nick, thank you so much for joining us today. This was a great presentation, and we appreciate your time.
Thank
And
you.
thank you as well for joining us. We appreciate it.
Thank you all, especially thank you, Christine. Thank you, Yesenia.